I please the court, Mr. Hurley. Good morning. My name is John Fitzgibbons. I'm a lawyer in Tampa, and I represent Cameron Heron in this appeal. I would like to reserve 5 minutes.
All right,
Your Honor. Thank you.
you got it. I have a question, preliminary question. You broke your case, your argument into 3 issues in your brief. Are you going to argue 3 issues separately, or are they kind of overlapping to some degree, at least issues 1 and 2?
Your Honor, the first 2 issues are the significant issues, the disparity and the abuse of discretion. The 3rd issue we don't feel is as important as the other 2. The other 2 are interrelated.
Because disparity of sentencing could be part and parcel of downward departure justification, right?
Yes.
So I'm not necessarily, I don't think there's a bright line separating those 2 issues. I just didn't know if you wanted to bring that out to my attention so I could focus on each issue separately, or you don't have a preference.
I think that some of the facts are going to relate to both, and I'll try to
That's fine.
do my best. Thank you, sir. This is a horrible case. There's no dispute about it. There's nothing good about it. It's tragic all the way around. The events in the case took place in about 30 seconds on a May Day in 2018. The 2 cars, the 2 young men stopped at Bayshore Boulevard and Gandhi, and 30 seconds and maybe 1 or 2 or 3 more later.
Mr. Fitzgibbons, you did a fabulous job briefing this. And
Pardon me, Your Honor?
you did a fabulous job briefing this and arguing it in the trial court, and we've read the
Thank you,
record
Your Honor.
and the briefs. So I have a question for you that ties a little bit to what Judge Valenti asked, and it is, I reviewed your arguments.
I have a little trouble hearing, Judge, sometimes.
So
I'm
sorry. Let me
Get
yell
to a
at you a
certain
little
age
bit
here.
better. Can you hear me a little bit?
Yes,
better now?
thank you.
Sorry about that. I reviewed your arguments pretty much separately, recognizing that issue 1 is a predicate to issue 2. And with regard to issue 1, right, the downward departure, you've got a very difficult standard of review there, such that the bottom line question is, is there no reasonable trial judge that would have refused to downward depart? I would like to focus on issue 2, just assuming, that it gives you a legal predicate, the fact that I'm sorry, the fact that there was a disparity. And so what I think the fundamental inquiry comes in under Sanders, right, was the trial court is justified in departing on this only if the record establishes beyond a reasonable doubt that this defendant, that Mr. Heron's culpability was no greater than that of Mr. Barano, right? And which leads to the same problem that I think you have with issue 1, and this is where I'd really like you to address the points. Isn't the trial court's determination of the answer to that Sanders question a discretionary determination? Each case stands on its own facts. It's a judgment call. It's the Fernandez case committed to the trial court's discretion. And your opponent has argued that they weren't equally culpable for, I think, 4 reasons, having to do with the black box data, the fact that Barano was 17, and that Mr. Heron's car, through random or into, however it did, Mr. Heron's car is the one that actually had contact. So can you address where the trial court legally erred in refusing to downward depart on the basis of disparity?
Your Honor, I think you have zoomed in on the key issue here. The equal culpability of Mr. Barano and Mr. Heron. And we think the court respectfully got it wrong. And for a number of reasons, because I think that drives so much in this case. First of all, the state, the judge did not give a lot of reasons in his, when he was pronouncing his decision. He seemed to rely very heavily on the state. And I even brought along a couple of the state's comments that they said during the arguments. Your Honor, we're here today because of the actions of Cameron Herron and, quite frankly, Cameron Herron alone. Main argument, which is the most obvious, Barano did not strike the two people. I can't stress it enough. I don't know why it's so difficult to comprehend the difference between this defendant and Barano. Cameron Herron killed them. His vehicle struck and killed him. But I think that that ignores the facts that we tried to develop in our brief. Two young men started out together.
They're drag racing.
Pardon?
They were drag racing. This is a form of vehicular homicide where it's almost presumptively, they're intertwined, obviously.
Inextricably intertwined.
And the evidence is what it is. We have one witness who says that Mr. Barano's vehicle was in front and that Cameron's vehicle that he wouldn't have been able to avoid. I forget the witness's name, Lewis, I think. And then we have some other evidence that seems to contradict that. So these are all evidentiary determinations that the trial court is making. And I'm just going to jump on the side for a minute here, a little segue. I was surprised based on my own research and the fact that nobody briefed it, to learn that there is no proportionality downward departure case, and you tell me if I'm wrong here, involving drag racing vehicular homicide sentencing, because they're always going to have two defendants at least. And it was a surprise to me that for as long as the statute's been on the books, we haven't had this case in the state of Florida. Am I right about that?
Yes, Judge, because we spent a lot of time looking, thinking the exact same thing. It just seems so normal that this would have occurred on different occasions.
And that puts us back, and I'm sorry, I don't want to beat the dead horse or use up all of your time, but I think that brings us back to what our role is, reviewing what the trial court did. And our role is limited to trying to find a legal error with the presumption that the trial court acted correctly and the evidence supports that decision. What did the trial court do here that constituted an abuse of its discretion in deciding that these two defendants were not equally culpable? They're based on evidentiary factors, admittedly narrow, but we've looked at the whole record, which is very well developed. And the trial court, there's a view of this, and I understand the empathy and sympathy in this case on both sides, but there's a view of this that the trial court was empowered to and did exercise his discretion to resolve these evidentiary differences and conclude that these two were not equally culpable. And I think that's the case law that we're confronted with. So help us find a legal error, or what you say is the legal error.
Yeah, I don't think that the evidence was that contradictory. As the young men drove up Lakeshore Boulevard, different people at different stages of the way observed things. Sometimes Mr. Barano was in the lead, sometimes Mr. Herron was in the lead. The state charged this, they arrested them together, they charged them the exact same information, they charged them with racing. The state could have charged Barano with racing alone and not vehicular homicide. They chose to put them together, and the Puccio case talks about the state's theory. That's been the state's theory in that particular case. That's been the state's theory all the way that the two of them were racing. And I think that what Mr. Lewis said is that there's just no dispute that at one moment Mr. Barano's ahead, he sees the woman and child, he cuts in front of my client. As Lewis said, my client had to go around him. And boom, and then unfortunately it happened.
So maybe one of the most compelling aspects of your argument on this point is that the trial court accepted when you went through the plea colloquy or the colloquy at sentencing, that the trial court used one set of facts for both sentence, to accept the plea for Barano and to sentence your client. And that argument has some appeal since the trial court, that gives you a place to argue that they were exactly the same. Talk to me about that.
You're right, Judge, because we did have as we put in our brief on this, that the plea colloquy, we went first. The state read the stipulated factual basis. We agreed, and then Barano comes in right after us, as we assume, and they don't even read the stipulated facts. They stipulated that we agree what was read previously.
And your opponent, who will address this, is likely to say, well, we were at the end of a very long, emotionally charged day, and we're on Zoom, and the facts are the facts, but that doesn't necessarily mean that there's equal culpability. I think that's what it...
Excuse me, the plea took place on December 31st. And Berno was sentenced on the spot pursuant to his agreement with the state. Everybody there felt 6 years is fine. Then our sentencing was several months later.
Did you ask for a PSI at that point?
No.
The judge ordered a PSI on his own accord or her own accord? There's reference to a PSI in the transcript, but we don't actually have the PSI.
I don't remember seeing one, Judge, and if there was one, I'm sorry for that. We knew all along this was a mitigation case. We just did.
Well, so my question is on your first issue, at least, if you proved mitigation and there was a legal basis where the judge could have downward departed, but then the judge has to do this weighing process under the case law to decide if that downward departure is the best sentence for this particular defendant. So my question is, if you prove downward departure grounds exist, are you saying the court's obligated to downward departure at that point, or they still engage in that second step and do the independent analysis?
Well, we would argue that we set forth this is abuse of discretion argument, the first one, that we presented. I know abuse of discretion is a very big hurdle to get over. There's no doubt about it. But we felt we presented enough that when we look at the definitions of abuse of discretion, and they talk about the Huff case and the Banks case talk about logic and justification as part of the definition of abuse of discretion. We just think with everything we presented, it was not logical to give one defendant 24 years, not depart, and another one 6.
So this case law you allude to comes from death penalty cases, where there's co-defendants, felony murder, things like that. And they generally, there's recourse if they don't get the same sentence. But you don't have any case law to say you have that same right to the same sentence as another co-defendant. I see distinctions here. I mean, I was a trial judge for a long time. If the state comes up and says, we've got a plea negotiation on party A, and you give me the facts and I can see the distinction, well, someone's left holding the bag. In this case, it was your client. He didn't get that benefit because obviously the state refused to give a negotiated plea to the person they felt was more culpable. And the facts on the record, the judge said, geez, you make the contact, he was speeding at 170 miles an hour the night before, the day of. It doesn't show, and you have an alleged adult, 18 years old versus 17. So there's enough for the judge to hang its hat on in approving plea bargain A and not going with the downward departure. Same reason the judge didn't have to give YO. I don't think there was a request for YO in this case, was there?
Yeah, there was, yes.
The judge rejected out of hand, but that's not part of your appeal.
And that was one of our grounds for departure.
Okay.
And Judge, I think it just boils down to this issue of culpability. We just don't see daylight between the two young men in this case. If the conclusion is there is a big difference in culpability, that's one thing. But this could not have happened without both of them in concert.
Well, here's the other thing that's a little bit confusing. Straighten me out of this. This is a vehicular homicide case.
Yes.
That emanated from drag racing. Well, street racing. Why would both people have to be charged with vehicular homicide if only one made the impact?
Because I think that the state's theory here was to join them together because they were concerned about certain things, one being that the impact speed was below the speed limit. And so they want to get the racing in there, I believe, so that to help their case. And I keep coming back to the culpability. Their theory was it was two individuals racing along, and the woman is struck. The only difference is at the last second, the other guy veers in front of my guy, and it happens. It could have been either one of them, and that's That's equal culpability. It seems that they've charged him again as
Reduced to
aiders and abettors, co-conspirators, and strictly
You just passed your 5 minutes. I don't know if you want to save that for rebuttal or if you want to come back and keep
I could
going.
talk for a long time, Judge, so I don't want to say everyone.
Everyone could, okay.
Thank you.
Thank you so much. I'll save you 5 minutes. Response?
May it please the court, Jonathan Hurley, the Office of the Attorney General, representing the police state of Florida in this case. Your Honors, real quick to bullet point this. There was no error in the process that the court applied during sentencing when it comes to following banks. Number one, there were 6 issues, bases asserted in their motion for downward departure. All 6 were recognized as legal bases by the court.
And 5 were accepted as proven.
5 were accepted.
And the disparity
1 was not. But from a standpoint of, let's analyze was there legal error? First of all, the court recognized all 6. When it comes to the one that it did not, the disparity issue, the appellate would argue that the record supports the trial court's finding that the evidence was insufficient to reduce this sentence from the lowest, from the LPS, from the lowest.
So I think your opponent has conceded that that's sort of a throwaway issue here,
Well,
issue 3. But stay with me. One of his arguments, and let's start at the top with issue 1, is that the trial court did abuse his discretion, among other things, because it was the trial court found, and I don't think there's any serious dispute, that 5 of the 6 bases were proven, were met, and disparity was the open question. But if I understand his argument on issue 1 correctly, it is that alone sets up a good argument for abuse of discretion, because you have 5 out of 6 mitigators for downward departure, and the trial judge blew past all of them and denied it. Can you tell us why that wasn't an abuse of discretion?
Well, to respond to your comment that the court blew right past them, I think if you read the record, I don't think
I did read the record.
Right, and I think the trial court painstakingly went through the totality.
When I say blew right past them, Mr. Hurley, what I mean is, he didn't, forgive me for a misuse of that term, he disregarded them in his decision-making, even though it's a significant quantum of mitigators, 5 out of 6. And your opponent's position is that was an abuse of discretion. If you've got 5 out of 6 and 1's in question, he should have granted a downward departure. This is issue 1. Abuse of discretion is a high hurdle. He's saying it meets that hurdle. What's your response?
With all due respect, I don't think the court ignored those first 5.
Let's say, you're missing my point.
Yes.
I'm not suggesting that Judge Nash ignored anything.
Mm-hmm.
What I'm suggesting is that everybody agreed. Nobody questions that 5 of the 6 mitigators in question were met. 1 was in question. It's certainly the subject of a legitimate debate. And nonetheless, the trial court didn't find a basis to depart. And is that an abuse of discretion? I read this record. I know that this judge took it seriously. We're taking it seriously. The state took it seriously. But the question now is, was that an abuse of the trial court's discretion on this record? And tell me why it wasn't.
It's not. And the reason it's not is because the court, again, is looking at all the aggravating and mitigating factors. And this is a judgment call. This is a subjective judgment call. As long as the court does its weighing and examines the record in totality, and yes, there were mitigating circumstances that you referenced to, Your Honor. There was also aggravating circumstances, which so the weighing process is a judgment call.
Then you've taken us right to issue 2. And weren't those aggravating your opponent's position clearly is that the aggravators, as you called them, aren't they present across the board equally in both of these defendants' conducts leading to this crime, this end.
Some of them may be, but there's also distinguishing facts and circumstances between the two co-defendants. If you again, going back to Sanders, the record has to show beyond a reasonable doubt that they're equally culpable in this case. Just looking at just reading the transcript of the plea hearing, you see that there's debate in essence, even though, again, this is the plea colloquy is justifying the charge. It's not settling who is more culpable in this case. It's not saying, okay, plea hearing, we've decided they're both equally culpable. That's not what happened here.
So that's your point to respond to using the same colloquy for both to accept the plea, and then as the basis for
the colloquy supports the state's position. The fact that on the record, which was not objected to, the colloquy, you've got two eyewitnesses. First of all, there's no question they're racing. There's no question that they're alternating positions of who's ahead and who's behind and so forth. Okay, that seems to be.
They're both endangering the pedestrians and other drivers.
And then to answer Judge Lynch's question, why was it really a homicide? Vehicle homicide, you drove recklessly, and because of that driving recklessly, you caused the death. Okay? And they had causation, so that could go along with that. Doesn't mean you were equally culpable. That just means you caused it, and your cause could have been this far, and this person's cause could have been up here. Well, and that's enough to get, for the crime.
Mention of death penalty cases. The death penalty have aggravators and mitigators, usually decided by the jury, sometimes the judge. And one aggravator can outweigh 100 mitigators. I mean, I don't see. And numerosity is a factor here. It's the aggravator versus the mitigation.
Well, right. To the point of whether or not it was whether or not it would have been proper to depart downward from the lowest permissible sentence. That is the culpability that the record has to show equal culpable. In this case, you had evidence by two eyewitnesses that said, no, the defendant was ahead of the co-defendant just prior to them being hit. Okay, so you have a discrepancy even within the plea colloquy. You also had video evidence which was shown just prior to the hitting that the judge got a chance to review. The judge looked at this video. The judge heard the colloquy. And the biggest thing of all, of course, is when it comes to whether equally culpable is one defendant hit the victims, the other one didn't.
And so, your opponent's position on that, I think, and this is my extrapolation, not his, but this is my read of it, is that in the passage of another 15 seconds or the shortage of 15 seconds, it could have been either of them. It was just a question of how the events transpired in the time that they did, where they were on the road. Barano was in front, Barano was in back. And the way you charge these defendants, it took both of them to commit the crime. So this was just a random happenstance of timing and logistics, effectively, not something that would distinguish between their culpability. That's what I think is a key aspect of your opponent's position. So, and that's what he's saying, I think, that the trial court abused its discretion with regard to essentially issue 2.
Well, whether the issue is what does the record show beyond reasonable doubt, not hypothetically what could have happened. That's not what we're debating. We're debating what does the record show. And that's what the state is presenting, that they were not, the record supports that court's finding that they were not equally culpable. In addition to that, they weren't similarly situated. Sanders says that they both have to be equally culpable and similarly situated. The glaring difference here is at the time of the offense, the co-defendant was a juvenile.
But they waived youthful offender for him on the plea bargain, didn't they? He was not sentenced as a youthful offender.
He, as part of the plea, but
he was charged as an adult.
He was charged as an adult, but the co-defendant could have pre-negotiated, and in addition to that, this was a negotiated guilty plea by the co-defendant. That unto itself is a legal basis for departure, which the defendant did not have a right to. So that's another distinguishing fact between the two. But the whole context of the juvenile versus adult, you know, the focus on the juvenile sentencing, frankly, is on rehabilitation. With adult, it's punishment. So pre-cooperation with the state by the co-defendant, they could have requested the court use its discretion and apply downward sanctions. Absolutely, they had every right to do so. Not by the defendant, maybe youthful offender, but not juvenile sanctions. That was not an option for the defendant. It was for the co-defendant. It's a totally different situation. But even, you know, argumentatively, if you want to say, well, they're equally culpable, it's still harmless. This court still had the pure discretionary determination whether or not it should depart in this case, even if the court accepted all 6.
Another judge, similarly situated, for lack of a better term, could have gone the other way. But this judge, who was on the ground, looking these people in the eye, looking at all the evidence, this is what he decided to do. And your position is that that was well within his discretion and proper under the guiding law, most specifically probably Sanders. Am I right?
That's correct. And to your point about whether or not there was racing, was there any case law on racing in departure? I couldn't find any case law strictly on this purely departure. Is there ever a case where a trial court was reversed on a purely discretionary review?
Well,
and under should have
that's another interesting question.
No.
Just an aside type question. So if the judge did downward depart, you wouldn't be filing an appeal because there was a legal basis.
There was a legal basis.
And you're stuck with that. I mean, usually downward departure, if a ground doesn't exist, the state can appeal that and get a reversal, but not if a downward departure ground exists and you don't like the sentence.
It was a subjective call, a judgment call made by the trial court. That's not reviewable. This was not an abuse of discretion in the context of the court somehow didn't apply did not apply its discretion from a due process standpoint.
Well, that's what mixing issue 2 and 1. If you separate out the second issue and say disparity of sentence, then that might be an abuse of discretion. I just don't know of any case law other than death penalty cases where you have a right to equal sentencing.
Your Honor, the Supreme Court of Florida no longer even considers proportionality. The Lawrence opinion, Lawrence versus State, 308, 3rd, 554, the 2020 case, the Florida Supreme Court no longer considers comparative proportionality of the sentencing as part of its review. So the Supreme Court doesn't even recognize proportionality review anymore.
So that's kind of your response in a nutshell to issue number 2?
Well, to number 3, for sure. Excuse me, to number 2. If you're saying, well, if the argument, with all due respect, to me it wasn't clear in the initial brief where this proportionality argument is coming in, but I can only assume that looking at the case law of proportionality analysis, the old proportionality analysis, that was the last step after the court reviewed aggravators and mitigators. Then finally you get the proportionality analysis under the 8th Amendment, which has now been taken out. But besides that, you could, I guess, the argument is that, okay, they're not equally culpable. However, they're relatively culpable or comparably culpable. And in that case, the court should have applied a proportionality analysis and so on and so forth.
But again, that was factored in the sentencing. The judge didn't give out the maximum sentence.
No,
it's a mid-range sentence.
The judge is within the guideline sentence. The lowest permissible sentence was 18.5. The statutory max was 30. The trial court.
Well, that shows that really
gave 24.
The abuse of discretion didn't really exist, because maybe an abuse of discretion would be just the maximum without consideration for the disparity in conduct.
If the court didn't do its job,
does it make
and apply its discretion, the court just said, you know what, I'm dying with these victim homicide racing cases. throw the book, and I'm going to go look at it. That, of course, would be.
Does it make a difference? Does it make a difference to your analysis that the other mitigator, or I think most of the other mitigators, not all of them, are statutory, and this one, this disparity, is judge-made law? Does that in any way change your analysis? I'm going to ask your opponent to address that rebuttal.
I don't think so.
Because what made me ask you that question is or maybe brought the question to my mind, was your argument that the Supreme Court no longer recognizes proportionality,
right,
which, take that out to its logical conclusion, this body of judge-made law could be eroding before our very eyes as a mitigator at all.
Well, again, without going too deep into the weeds of proportionality, which is kind of moot at this point, again, proportionality analysis is distinct because you're going beyond weighing aggravators and mitigators. In this case, proportionality, now you're reviewing, geez, in all these Supreme death penalty cases, let's take a look at the situation, because death is different, right? We don't have an opportunity to downward depart. You're either getting life or you're getting death. And so from that's why there was a proportionality analysis under the Eighth Amendment and so forth. But it doesn't really apply. First of all, it's gone. It's not longer considered by the Supreme Court. In addition, here, that's not really an obligation what the court had to do. The court had to look at the facts in this case and weigh, which the court did painstakingly in the record, the aggravators and the mitigators in this case. We're dealing with 102 miles an hour on Bayshore Boulevard, 11:30 in the morning. Everybody knows Bayshore Boulevard, what goes on. I'm sure everybody's walked Bayshore Boulevard, bikes. It's just gotten more and more packed over the years since when I used to live on Bayshore Boulevard. That was egregious to go that kind of speed on that particular. We're not talking in the middle of some rural road out in the middle of county somewhere. We're talking about Bayshore Boulevard. Second, the impact, the victim, the harm in this particular case. The mother,
Egregious.
an infant, I mean, the whole family's wiped out. So to say that no reasonable juror would rule the way this court ruled, the state just doesn't agree with that. Questions?
No, thank you. I've saved you 5 minutes.
Thank you, Your Honor. One or two factual comments. Number one, we believe the videos help us a lot. There were videos from several residences along Bayshore Boulevard. They're not the best, but what they show are the two cars going, and they're like zoom, right behind each other. The detective, homicide detective Jakes, testified that the Nissan at all times was during these times was right behind the Mustang. They were very, very, very close to each other at the time of impact. If you have one of these things you see on NASCAR where they have the arrow pointing at the car and the distance between two cars, you'd have 1 second. We've done time and distance measurements. They're like a second behind each other along the way here. And I just do not see the difference in culpability. If that is the aggravator being that my client struck the two people. But I just don't see how within a second or two or three, it could have been the other. Two peas in a pod, two cars driving together. And that's what turned everything that the state has said and the court in its limited reasons is my client's car struck the people, the other car didn't. Therefore, night and day difference, 6 years here, 24 years here. You know, they had to nail somebody here really bad. And we know that. And that is, my client was the scapegoat because at the last second, he's the one that hit. Barron would be up here making the same argument, I suspect, if the rules had been a couple seconds later. Also, when it comes to abuse of discretion, when you look at Huff and Banks, you know, the Supreme Court talks about that discretionary power is not without limitation. And the test requires a determination of whether there is logic and justification for the result. And I think in this instance, where we proved 5 out of 6, where the judge said, I agree with you. You did it. You did it right. And then disparity was the only one he didn't agree on. That's a lot farther than in many cases. But I just don't see the daylight here. And to give this young man, death is different, I agree. But to give this young man, 20 years old, 24 years in prison, he had just graduated from Tampa Catholic. He's never been in trouble. No alcohol or drugs involved in this case by anybody.
Well, let me ask you a question. Would your argument be the same if the co-defendant got 24 years in prison also?
Oh, it
Did
would.
the other person get off too easy, or your client got way out of proportion? I assume you're focusing on the latter.
Yeah, that's a hard one to answer. I mean, I would probably say,
I'm just saying that takes your thunder away.
well,
Maybe they
except that,
screwed up in the first case.
but the state felt the 6 years was entirely appropriate for.
It was a negotiated plea, and the court approved it. So the court obviously approved it. But you're not here on that case, so I don't want to.
And the court was, the court was going to approve it. There's no doubt. And it was, they wanted my client, and they reached the agreement with the other one, knowing that we were going to plead anyway. I mean, it was.
Well, was there part of the agreement that the other client, the other co-defendant would be required to testify if your client chose to go to trial?
Technically, yes, but really, no. He wasn't going to testify. They never listed him as a witness. He and the debriefing.
You see what I'm saying? Now, that's another factor that no one's really argued. We assume that's a factor because he pled out. He doesn't have a Fifth Amendment right at that point.
It's a smokescreen, Your Honor, because as we understand, we got a Brady statement that they did a very quick debrief, they being the state of Barano. Barano said we were not racist. And they weren't going to call him in 100 million years. And it was a kind of strange proffer. The prosecutor went over to the defense lawyer's office. The police officer, Detective Jakes, didn't even know about it. It was window dressing. That's what it was. It was window dressing.
You're down to about a half a minute. I don't want to stop you, but.
Well, I guess the point I would like to make as much as I can is that there's no daylight, like I've said a couple of times, between these two young men. If they're equally culpable, and I believe if they're equally culpable, then this sentence of 24 years versus 6 is excessive. And
Thank you. Thank you.
if I could conclude, Judge, with one comment. I've been privileged to practice this profession that I love for over 45 years. This is the case that keeps me awake at night and always will. Thank you.
Well, thank you for telling us. Take the next case. If I mispronounce the name of the next case, I apologize. It's Radu versus Crasium and Nicoletta versus Russo. All right. As soon as they clear out, you can come on up.